Introduce yourself, please.
Yes. Good morning, Your Honor. My name is Greg Brown of the Knox County Bar. I represent the appellant, John Chilton in Centennial Village.
What are we going to have over here? More than one argument?
Yes, Your Honor. I guess if the court would indulge us, Mr. Kaiser and I would like to see, I guess, where the opening argument for the appellant goes and announce our split at the time, if that's okay.
That's okay. Just announce it whenever the first one of you comes up, announce it then.
Thank you.
So we know. All right. Go ahead.
Your Honor, as a preliminary matter, we do have a motion to strike.
We do, counsel. We'll address that in the opinion. I suggest you just proceed with the merits of the appeal.
Okay. May I please reserve 3 minutes?
3 minutes rebuttal, that'll be fine.
Yes, please. Again, may it please the court, my name is Greg Brown of the Knox County Bar. I'm here on behalf of the appellant in this case, and I'm happy to be here. Thank you for hearing this appeal. My client is a retired banker who engaged in the development of an apartment complex up in Anderson County. And he engaged Fenton White, the plaintiff in this case, F.W. White and Associates, is Mr. White's operating business, engaged him as a consultant in connection with the development of these apartments. And there was a 2007 contract by which Mr. White worked for Mr. Chilton, and it said that if Mr. White produced a sale to one of 3 specific buyers, then he could earn a commission. And that was a 2007 contract. There was never any sale to those people, and that commission never happened. The next thing that happened was a 2008 written consultant agreement in which Mr. Chilton agreed to pay to Mr. White $5,000 per month for his consulting services. And that went from 2008, I think the last payment was made in mid-2014 or early 2014. During that time period that Mr. White was working for Mr. Chilton obtained a loan, a HUD loan, through Oppenheimer, which was the coordinator for the HUD loan. Mr. White went to Oppenheimer and kind of worked both sides of that and made a deal whereby he would get 1% of the loan value. And he ultimately received a check from Oppenheimer for $211,000. HUD regulations and the loan documents required that Mr. White could not be working for the borrower and the lender at the same time. He did, however, collect $5,000 per month from Mr. Chilton for a period of time until Mr. Chilton found out and suspended those payments for a while. Through the course of their relationship, Mr. White was always seeking to get a piece of the property. He wanted a percentage of the sales price to be treated as essentially as a partner in this apartment complex, notwithstanding the fact that he was being paid $5,000 a month for his consulting services. Ultimately, they had a meeting in August of 2012 that's detailed in our briefs, and there was never any agreement. There was never any written modification of the 2008 consulting agreement, which required that any modification would be in writing and signed by the parties. That never happened. Ultimately, Mr. White was terminated, and in December of 2014, Mr. Chilton entered into a contract to sell the apartment complexes. At that time, Mr. White went to attorney Greg Pratt, and Mr. Pratt prepared what he called a memorandum of contract. And the memorandum of contract was signed was recorded in January of 2015. And the memorandum of contract said several things. It said that there was a grantor and a grantee. Now, keep in mind, there was never a written contract between Mr. Chilton and Mr. White for any kind of commission, nor was there ever any right to a lien. Mr. White was not a contractor or a subcontractor. He made no improvements to the real property. But the memorandum of contract references Mr. Chilton as a grantor, Mr. White as a grantee, incorporates a property description, a legal description of the apartment complex property, said that Mr. White had provided, quote, services related to real property and improvements, and referenced a, quote, signed writing, unquote, which it said was attached to the memorandum of contract. Of course, there was no signed writing. That's not in dispute. And if you go to the Registry of Deeds in Anderson County and look up this memorandum of contract, there is no attachment. The only The only attachment is the legal description of the property. There's no contract attached, despite the reference in the document to a signed writing. The effect of this, now Greg Pratt is an attorney. He is authorized to write title insurance. He is a real estate attorney. He prepared this memorandum of contract for Mr. White. Mr. Pratt signed it on behalf of Mr. White, and it was recorded. The effect of that, as any title attorney would know, is that it created a cloud on the title to the apartment complex. The result to Mr. Chilton was he lost $125,000 that he was entitled to due to the seller's delay in closing. The purchase price, because the memorandum of contract said Mr. White was entitled to $600,000, the seller reduced the price by $625,000. And then on top of all that, the seller required $900,000, 1.5 times the amount claimed by Mr. White, to be put in escrow. $900,000, this was 2015. Today, that $900,000 belonging to Mr. Chilton remains in escrow, and he has never received it until this time. Mr. White ultimately filed a claim for breach of contract, and the second amended complaint, which is operative, says that he's entitled to $600,000 as a commission, essentially, on the sale of the apartments, or in the alternative, quantum merit. Those were the two claims, and after a bench trial, Mr. White's claims were dismissed, both for breach of contract and for quantum merit. They were dismissed with prejudice. The lien, such as it is, the cloud on title, was declared void by the court, and the court ordered that Mr. Chilton was entitled to receive back his $900,000 in escrow. However, the court went further and said that it perceived that there were certain months during their relationship where Mr. White was not paid $5,000 a month. And the court on its own, this is relief never asked for in the complaint, never argued about at trial, the court on its own awarded Mr. White $75,000 based on the 2008 contract, $5,000 per month for 15 months that the court selected out of their relationship. We made the mistake of asking the court to alter.
The court first found that 2008 agreement,
Yes.
that the parties were bound by that agreement, right?
Yes.
That was, okay, go ahead.
Yeah, and that was terminated by a writing in 2012, whereby Mr. Chilton said, I'm going to pay you through November. And that was notice, okay? There was no, all the contract required was notice of termination. It did not require an amendment or a modification. So notice was given in 2012 that he was going to be terminated. Mr. Chilton did, in fact, pay him beyond that point. He testified that he was continuing to do some work, but he was given notice of termination in 2012. Again, we made the mistake of asking the court to alter or amend, in which case, and it found another 10 months of this $5,000 per month that it felt Mr. White was entitled to, and increased that award to $125,000. Again, this is not relief that was ever requested in any pleading. It was not argued at trial. It is just not something that the parties were seeking, and both of Mr. White's counts, both of his claims for breach of contract, asking for $600,000, and for quantum merit were dismissed with prejudice. Now, the first thing that happened is that we filed a motion for summary. Mr. Pratt filed a motion for summary judgment. The court granted it based on the litigation privilege. Mr. Pratt, the litigation privilege here has 4 components to it. One, that the attorney be acting in the capacity of counsel, which Mr. Pratt clearly was counsel for Mr. White at that time. The second requirement is that he be acting in good faith and on behalf of his client, and that's the one we take issue with. And then there be a nexus, that it be related to proposed litigation, and that there be a nexus between the attorney's conduct and the litigation. There's case law out there that says if you file a mechanic's lien, which the statute requires you to do in preparation for enforcing it, filing a suit to enforce it, that is the recording of that mechanic's lien, even if there's an error in it, is covered by litigation privilege. This is completely different. This is not a statutory procedure, and the court made no good finding regarding Mr. Pratt's good faith. He prepared a document with the grantor and grantee about services related to real property, said a signed writing was attached when not only was it not attached, but it didn't exist. And he recorded that as a title attorney, he would know that that would cloud the title and impair Mr. Chilton's ability to sell this apartment complex. It was our position that there was no good faith. The court made no finding regarding good faith. And we introduced the testimony of attorney Chris Martin, who said that Mr. Pratt could not have recorded that memorandum of contract in good faith. The case law on this is clear. It's not enough simply to be doing it for a client, because the UNARCO case says, it says so long as the attorney does not employ wrongful means. And here we have a title document, a document impairing Mr. Chilton's title that was filed, claiming there's a written contract when there wasn't one. Mr. Pratt had never seen one. And I would submit that that is wrongful means, that there was a lack of good faith, and the court should not have granted summary judgment to Mr. Pratt. Just talking quickly, because I've got 2 minutes left. Although the court found that the memorandum of contract as a lien was void and invalid, the court dismissed the claim for slander of title against Mr. White. And in doing so, the court found that Mr. White clearly believed that he was entitled to the money, and that was enough to negate the element of malice in a libel of title or slander of title claim. However, that's not the law. The law says that they have to have a good faith belief in their claim of title, that they have a good faith belief to the lien, and that's not here. We don't have that here. What we have is the assertion that because Mr. White consulted an attorney, he's protected. So on the one hand, we have Mr. Pratt, who's protected because he had a client, and on the other hand, we have Mr. White, who's protected because he consulted the attorney. And so their argument, should this court uphold it, puts all of these parties who, without any doubt, filed a void cloud on title and caused a large amount of damages. It insulates them completely from liability. Very quickly, the last two things that I want to point out to the court is that the $900,000 owed to Mr. Chilton was held in escrow. It was not damages owed by Mr. White. The money was there. What Mr. Chilton suffered was the loss of use of that money. So his damages were what he would have made from that money if he had had access to it from 2015 to the present. And the court basically said that prejudgment interest is the remedy for that, and the court held that it did not have authority to award damages for this, and that's something that we think the court's simply incorrect about. And I'm out of time.
Thank you, counsel. You have your time for rebuttal. Glad you all were able to negotiate a deal there. Yeah.
Your Honor, Matthew Grossman, again, of the Knoxville Bar, assisted by my associate Rebecca Harbin. As the court's aware, Mr. Kaiser and I represent separate appellees, and we've agreed I will take, I guess I'll go with 8 minutes, and Mr. Kaiser can have 7. So that's kind of that's the kind of generosity I got.
All right, I'm sorry. You turned away and I couldn't hear.
Oh, I'm sorry, Your Honor. We'll take. I'll take 8 minutes for my argument.
8 minutes for you and 7. Okay. 8 minutes here.
Again, this is a case that's been pending since 2015, so it's obviously very difficult to try to summarize everything to this court in the course of 8 minutes, or even 9 if I'd taken that. I think I would just like to very briefly hit upon some things that I think are important. In this record, and it's in the technical record at page 1114 and 1115, the trial court made an express finding that Mr. White did not act maliciously with respect to this memorandum of contract. And in fact, to quote, the court, this is on technical record 1115, the court finds White did not act maliciously in recording the cloud on title. and as such, count one of defendant's counterclaim is hereby dismissed with prejudice. I think that couldn't put a finer point on it. The trial court had the opportunity to observe the witnesses, and that was what the trial court found. And unless we are way out of bounds here, it's really, as this court is aware, it's not really the role of this court to go kicking around on credibility determinations, and obviously credibility determinations can be inferred from the rulings, and that's what we have here. One thing that Mr. Brown said that is somewhat puzzling to me is that the trial court dismissed our breach of contract claim. Well, the fact that my client now has a $125,000 judgment belies that. Basically, if you look at the pleadings, you liberally construe them, the addendum said enforcement of the contracts with an S. Obviously, Mr. White would have much preferred to have been awarded $600,000, but the trial court, in evaluating the evidence, found that there was no agreement. And the thing that is interesting here is the entirety of Mr. Chilton's defense of Mr. White's claim for $600,000 all revolves around the 2008 contract. So just to back up a little bit, we have a 2007 contract expressly superseded in 2008. It has an attorney fee provision, and it has essentially the $5,000 a month monthly payment. We have negotiations in 2012, which, as the trial court found, and we have not raised on appeal, did not result in any new contract. And the result is the 2008 agreement remains in place until terminated. Now, what does that mean here? Well, Mr. Chilton kept on paying it. Everybody's acting like it's still in place. And Mr. Chilton uses that 2008 agreement, again, to demonstrate the lack of liability for the $600,000 claim. You simply can't have it both ways. And I must respectfully disagree with Mr. Brown. I'm fairly certain that in the course of these proceedings, we documented for the trial court which months Mr. White had not been paid for and presented that as in the course of closing argument. Okay. A couple things I'd also like to point out in the short period that I have with you is, again, and we raised this in our brief, and Mr. Brown addresses it in his reply brief, for which we've obviously moved to strike. Mr. Chilton failed to raise any evidentiary issues as issues on appeal. Now, he drops footnotes where he recites to proof that was only in the record as an offer of proof on a couple occasions, but it didn't raise it as an issue. And even in the reply brief where the court to consider it, I still don't discern a basis for the admissibility of the evidence that the trial court excluded. And that's very important here, because the two chunks of evidence that were excluded were, and again, we have to make a little bit of a distinction between the Chris Martin declaration that was used against Mr. Pratt in summary judgment. That's a summary judgment issue. What we had at trial is we had Mr. Martin as a live witness. That's the universe of the evidence for my client's purposes. And Mr. Martin attempted to offer testimony as to my client's state of mind in causing the recordation of the memorandum of contract. I objected. It's basically, and the trial court sustained it. And in essence, my objection was a lack of foundation. There wasn't any foundation for Mr. Martin to testify as to what my client was thinking, what he felt in his heart. Again, I think that's critically important in terms of this court's analysis of the dismissal of the slander of title action, because there simply is no positive evidence in this record that Mr. White acted with any sort of malice. And in the absence of such, Mr. Chilton can't support his claim. Now, the other large piece of evidence that is brought up as an issue in reply, not in the principal brief, involves these alleged damages. And frankly, they're fanciful. What we have is a gentleman many, many years after the fact coming into court with a stack of, again, hearsay documents, Zillow listings. And he says, well, I would have invested in each one of these properties and I would have made $3 million. No, you can't do that. That's speculation. Anyhow, so those are the kind of the evidentiary issues that I would like the court to, frankly, summarily overrule as matters on appeal because they weren't properly raised. But even getting to the substance of it, there's no basis for this court to disturb the trial court's findings in that regard. Again, I think it's been thoroughly briefed, but I'll just touch on it briefly. We believe that Judge Cesano's opinion in the DeSangre versus Meyer case applies to the situation in terms of the privilege that comes with the recording of that memorandum of contract. The trial court found that essentially he couldn't find that it was connected enough. But basically, we have a restatement that I believe is adopted in Tennessee. It's Restatement of Torts 587 that basically says in order for a defamatory substance to be privileged, it just has to have some relationship to the proceeding. This was recorded in month one. Month one lawsuit was filed in approximately month 4. It's again, I believe, and again, I don't believe we had to affirmatively plead that because, in our view, the absence of a privilege is part of the burden of pleading on the plaintiff in a defamation case. We filed included in our answer is a standard 12026 fails to state a claim because as pled, it fails to state a claim in the absence of pleading that the statement was not privileged. Okay, and in the minute I have left, I'll Yes. Last thing, we were asking for an award of attorney fees on appeal. We are also asking for the trial court to remand this case for an award of attorney fees at trial. The 2008 agreement, which is again the basis of Mr. Chilton's defense throughout these proceedings, contains that provision, prevailing party attorney fees. The fact that my client won $125,000 and not $600,000, I don't think makes him any less the prevailing party here, which is what Mr. Chilton is now arguing.
Well, he may feel he's a little less prevailing party.
A little less, but he's still prevailing.
Okay, go ahead.
And I dare say Mr. Chilton is not a prevailing party. And also, again, and I'll give Mr. Kaiser the rest of his time, similarly, to the extent that any attorney fee request is made by Mr. Chilton on appeal, that was waived by not raising it as a separate issue in the opening brief.
Thank you.
Thank you, Your Honor.
Counsel, 7 minutes.
Please, the court, I'm Morris Kaiser. I represent Gregory Pratt. First of all, I want to thank Mr. Grossman for giving me 1 minute more than we even agreed on just now, so I appreciate that. Initially, I would want to talk about in the brief that I filed in response to the appellant's brief, there was an assignment of error pertaining to a challenge to the trial court's finding, that a fact that was totally without any support in the record whatsoever. And so that was asserted as an issue on appeal. In Mr. Brown's response brief, or reply brief, that was not even discussed. So the way I understand it, he has conceded on that point. But I want to go ahead and put that out there first. The litigation privilege that we've been talking about, as the case law is developed in the state of Tennessee, and the earliest case on that's back to 1856. But as the case law has developed up through today, it's very broad. It applies to pre-litigation statements and actions, and applies even if the statement is malicious, false, or known to be false, even if there is a finding of malice, ill will, or improper purpose, and even in the case of false or fraudulent pleadings, affidavits, or court testimony. And that's a compilation of the findings of the cases that are cited in my brief that show the breadth of that privilege. On page 18 of the appellant's brief, they state for the litigation privilege to apply to an attorney's conduct prior to the commencement of litigation, and then they quote the 4 factors out of the UNARCO case. And then after doing that, the appellants say at issue here is the second element, and specifically, so in essence, they have conceded the other 3 elements, 1, 3, and 4, but they take issue with the second element. Specifically, they say the trial court made no findings relative to the second element in the order granting summary judgment for my client. The second element in UNARCO is that the attorney was acting in good faith for the benefit of and on behalf of the client or prospective client, not for the attorney's self-interest. To this point, paragraph 19 of Mr. Pratt's affidavit states, "I determined that F.W. White and Associates had a good faith claim for breach of contract and/or quantum merit against Centennial Village Apartments, LLC, Centennial Village Development, LLC, and/or John R. Chilton for services performed relative to the property subject to the memorandum of contract and right to receive payment." And then in paragraph 25, he states the MOC, memorandum of contract, was to be recorded for the purposes of protecting and enforcing F.W. White and Associate LLC's rights and interest in the property. Now, in the order granting summary judgment, the trial court stated, this is a quote, the court must analyze Mr. Pratt's conduct with the factors set forth in UNARCO. And that's the case from which that second element comes. It's the case cited by the appellants in this brief. And then the trial court continued and said, after considering the relevant factors, and again, we're talking about the UNARCO factors, after considering the relevant factors with Mr. Pratt's conduct and the allegations against him, the court concludes the litigation privilege applies to bar all the claims that were asserted against him in third-party complaint. Now, these statements by the trial court demonstrate that the trial court did, in fact, make a finding with regard to all of the UNARCO factors, because the trial court started that part of the order by saying the court must analyze it in connection with those factors. Those factors, all four, were set forth in a previous page on the opinion. And the trial court did make some findings, including the finding the court does not find that Mr. Pratt was acting personally or for his own interest. But what the appellant complains about is the trial court did not say, I find that Mr. Pratt acted in good faith. That's what the appellant is arguing about. However, I would submit that when the court says I will analyze this in terms of UNARCO and after considering the relevant factors of UNARCO, I find that he is protected by the litigation privilege, then I submit the trial court absolutely did consider those factors. And it's also, and those factors are supported, that finding is supported by paragraphs 19 and 25 of Mr. Pratt's affidavit, which I read into the record just now. Now, one thing Mr. Brown said that I respectfully take issue with, if I wrote this down correctly, he said that Chris Martin, whose affidavit was filed in opposition to the motion for summary judgment, said that Pratt could not have recorded that memorandum in good faith. Mr. Martin never said that. That is never in his affidavit. It is not in his affidavit. Mr. Martin certainly is very critical of Mr. Pratt in his affidavit. Does not say kind words about him, but he never controverts Mr. Pratt's good faith. He doesn't talk about it at all. Now, the other thing is that I would point out that even if the trial court were in error by not specifically calling out Pratt's good faith as a finding, there is a principle, your honors know it well, that the appellate courts have the authority to affirm a trial court's decision if it reached the right result for the wrong reason. And the same principle applies, and that is that the evidence demonstrating Pratt's good faith is in the record. In paragraphs 19 and 25 of his affidavit, it's in the record. And even if the trial court were in error for not specifically calling out the Court of Appeals, your honors can affirm the trial court's decision nevertheless, because that evidence is in the record. So for those reasons, I respectfully request that your honors affirm the judgment entered for Mr. Pratt. As to the appellant's issue about damages and Mr. Grossman's response there too, if your honor please, Mr. Pratt adopts what Mr. Grossman said. Thank you very much.
Here's the appellant rebuttal.
I believe, I was trying to find it so I could show it to the court in our briefs, because I think we did quote the language from Mr. Martin in his testimony about what a title attorney in the position of Mr. Pratt advising Mr. White, what they could have known. I believe that if it's not in the declaration, it's in the testimony, and I believe we quoted it for the brief. So I just wanted to just respond very quickly to that point raised by Mr. Kaiser. Turning to Mr. Grossman's argument about judicial immunity, again, that privilege, judicial privilege, this is an affirmative defense. It's expressly required by the rules that it be pled. It was not pled. This is something that they came up with later. And again, the argument, if it were taken on its face, is that libelous parties could insulate themselves from liability simply by filing a frivolous lawsuit thereafter and make all of those statements protected. And that's clearly not what the law intends. But I don't think the court needs to reach it, given the fact that it was an affirmative defense required to be affirmatively pled. The issue of the 2008 contract and payments that were made for $5,000 thereunder is relevant to Mr. White's claim for quantum merit. You cannot have a claim for quantum merit when you have a contract covering the subject matter between the parties. That's the context in which that contract and those payments were discussed at trial. It showed the scope of that contract and that there could not be a claim for quantum merit, and the court agreed and ultimately dismissed the claim for quantum merit. To the extent that Mr. White is now arguing that issue of missing payments of $5,000 per month was tried by consent, the case law is clear that when that evidence has other relevance, like it does here to the question of quantum merit, the court has to be very careful in finding consent. What you're not going to find anywhere in any pleading is where Mr. White said, I was not paid $5,000 per month for these months and I want the court to pay it. It's not there. And there's no request, an argument, or anywhere else for the court to award Mr. White $5,000 per month for any number of months.
What do you say to his argument, as I understand it, that the complainant asked and to enforce the contract? I mean,
I think
broad enough to.
The language. What he? Let me show the court clearly what it says, because this is the ad damnum provision. Wherefore, plaintiff respectfully prays the court grant plaintiff relief as follows: that the court specifically enforces the terms of the agreements and that defendants pay damages in the amount of $200,000 plus accrued and unpaid interest and attorney's fees, and that defendants be ordered to pay plaintiff $400,000 immediately upon the sale of Centennial Village apartments plus accrued and unpaid interest and attorney's fees, and that in the event this court finds no enforceable contract between the parties, defendants be liable to plaintiff for $600,000 as services rendered by plaintiff and benefits received by defendant, costs and expenses, pre-judgment, post-judgment interest, and such other further and general relief to which plaintiff may be entitled in law or equity. So to the extent that such other further relief or enforcing the contract could be construed as encapsulating this request for $5,000 per month for certain months, that's not enough to put the plaintiffs on notice or put the defendants on notice that we're litigating that question. This was very clearly a lawsuit for $600,000. Pursuant to some theory of modification for the contract.
Counsel, you've used your time. It goes fast, doesn't it?
Yeah, it does. Thank you.
Court's thanks to all counsel. We appreciate your briefs and your oral argument on this. I think we understand where the issues are and your client's positions on them. So thank you very much. If you would, y'all are excused. I understand we have a class here.
Yes, Your Honor. We have a first-year law class from the University of Tennessee College of Law. I'm their professor of law development, and they have their oral arguments tomorrow.
Oh, okay. Yeah. Well, if you'd like, we'll adjourn court, but we'll stay here, and if your students have any questions they want to ask, they can ask. They can't ask how we're going to decide the cases, of course, but we'll be happy to address any questions, if any. So if you would, just recess court till 1:30 this afternoon.
Yes, sir. All rise. This Honorable Court of Tennessee is in recess until 1:30 this afternoon. Thank you all for joining us.
Yeah. I would ask that if they have any questions, some of us are older and have difficulty hearing great in this courtroom, so if y'all want to move up closer, that will help certainly me out.